response to the issues raised by the counsel for the accused. She went legal. She asked that the court should make independent view and not driven by mercy, as alluded to by Counsel Njiru. She submitted that the court in granting bail should be guided by the existing bond and bail policy and the relevant laws. She submitted in objection to the accused admission to free bond. She asked that the court should consider a bond of bail that is consummary to the offense. She had either no objection to the accused admission to bond. This is the determination. The law on accused admission to bond is clearly spelled out in Article 49(1)(h) of the Constitution. I deem it fit to restate, quote, an accused person has a right to be released on bond or bail on reasonable condition pending a charge of trial unless there are compelling reasons not to be released. The constitutional rights to bail as guaranteed under the Constitution is therefore subject, the constitutional right to bail as guaranteed under the Constitution is therefore subject to being granted on reasonable conditions pending trial or unless compelling reasons not to do so, and does not mean that the right is absolute. In the end, the discretion to grant bail and determine the conditions rests with the court. In exercising this discretion, the court must seek to strike a balance between protecting the liberty of the accused person and safeguarding proper administration of justice. This was well explained by Mativo J, as he then was, in Republic vs. Danford Kabage Mwangi 2016 EKLR as follows, quote, granting bail entails the striking of a balance of proportionality, considering the rights to the applicant who is presumed innocent at this point on one hand, and the public interest on the other hand. The cornerstone of the justice system is that no one will be punished without benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that the accused person will appear for trial and not corrupt the legal process by absconding. Anything more is excessive and positive. End of quote. The conditions for grant of bail, the conditions for grant or refusal of bond and factors for consideration have been broadly identified as follows. These are what the courts must consider. 1, the nature of the charge. 2, the strength of the evidence which support the charge. 3, the gravity of the punishment in the event of conviction. 4, the previous criminal record of the accused, if any. 5, probability that the accused will not surrender himself for trial. 6, the likelihood of the accused interfering with witnesses or suppressing any evidence that could incriminate him. 7, the likelihood of the accused interfering with witnesses or suppressing any evidence that could incriminate him. 8, the likelihood of further charges being brought against the